Thanks, Vanessa, and good afternoon, everyone. Thanks for joining us today. For those of you who don't know me, I'm Richard Mark. I'm one of the partners in the team, and I specialize in technology and outsourcing contracts. The particular case I'm going to have a look at now is quite an important case in the technology sector, but also more generally. It's the case of BSkyB and EDS. You may have heard of this case. It's quite notorious for reasons that we'll come on to. The facts of the case are fairly straightforward, really. The contract concerned software development project where EDS developed or tried to develop a customer relationship management system for BSkyB. The project was worth £48 million. There was a liability cap in the contract of £30 million, but things went wrong pretty early on. There were some quite tight timetables in the project plan, which very soon became apparent were not going to be met. And what happened was Sky, in the end, simply stepped in, took over the project effectively, and completed it itself. And as you can imagine, they were pretty cross at having to do that and to incur costs far in excess of what they had contracted for, and as a result sued EDS. And the reason why this case is so interesting is because whilst there was this liability cap of £30 million, in the end the court awarded on an interim basis £200 million. And in fact ultimately the case was settled, and the settlement amount was reported to be £318 million, which, as you can see, is more than 10 times the contractual cap of liability. And the question, of course, is how did they manage to do that? And the way they did that was by claiming that EDS had made fraudulent misrepresentation. We'll just have a look at fraudulent misrep in a bit more detail, because it's quite an important point, because in this case and more generally, if there is a fraudulent misrepresentation, then no cap of liability is effective to cap the damages that might be awarded as a result. And for there to be a fraudulent misrepresentation, there has to be basically four things. First of all, misrepresentation of present fact with no belief in its truth, with the intention that the other party, in this case Sky, would act on it, and Sky, in this case, acted and relied on it to its detriment. Now, in this case, the representation that was complained of as being fraudulent was what was referred to as the timing representation, which was the representation that EDS made that they could effectively deliver a pilot of the project within 9 months of starting. And you may say, well, hang on a second, I thought you just said there had to be a present representation, a representation of present fact, and how can a prediction that a system will be delivered in 9 months be a present fact representation? Well, the way they got around this was by saying, well, in making that representation, you, EDS, implicitly represented that you had made a proper analysis of the time it would take to deliver the project, and you impliedly represented that you had reasonable grounds to believe that you could deliver within those timescales. As for evidence of dishonesty, well, this was in some abundance in the evidence. The court saw various documents that illustrated that whilst EDS were telling BSkyB that they could deliver within this 9-month period, there was a lot of internal communication which showed that EDS really didn't believe that it could do this. There were internal risk reviews, the so-called red team review, which was the sort of the internal objective review by the delivery team as to whether they could actually deliver within the timescales put forward by the sales team. And these reviews indicated that they could not deliver to the timescales that they talked about. And there was evidence that they were effectively making amendments to the presentations to their clients, BSkyB, to convince BSkyB that they could, when EDS, in fact, knew they couldn't. One of the most extraordinary aspects of this case was the lead sales person from EDS, Joe Galloway. And this particular individual was quite literally unbelievable. He was found to have perjured himself in court because he was challenged about his MBA, which was on the CV that was part of response to tender documentations, and he said that he had completed this course, this MBA, at a college called Concordia College on the Caribbean island of St. John. And he was challenged about this and was said that surely this was just one of those online fake degrees that you can get by simply paying for. And he denied this vehemently, and he was slightly undone when the lead counsel for Sky produced an MBA certificate from the same university, but which had been awarded to counsel's pet dog, Lula. And rather unfortunately for Mr. Galloway, the certificate that Lula had been awarded had better grades than the one that Mr. Galloway had been awarded. But notwithstanding all this, he was nevertheless quite insistent that he had attended this course and was saying he had vivid memories of flying in to St. John to attend this course. And then there was further evidence produced that this island of St. John didn't have and had never had a runway, and therefore wouldn't have been possible for him to fly in. And so it went on. And I think some people were tempted to say, well, this case is rather extraordinary because Mr. Galloway was rather extraordinary. In other words, because he was so unbelievable that this gave BSkyB, if you like, more evidence than they needed to show that there was fraudulent activity here. And I think there is a degree to which that is true. And I think it's fair to say that establishing fraudulent misrepresentation is still a relatively high threshold to achieve. One of the things that EDS could have perhaps helped themselves with beforehand would have been if they'd had a proper entire agreement clause. The court had a good look at the clause, and the clause sets out some of the sort of things you'd expect to see in an entire agreement clause. In other words, a clause which sets out that all the terms of the agreement are the ones set out in the agreement and that nothing else is relevant to the agreement. But unfortunately for EDS, they didn't have the key non-reliance provision that you need in a proper entire agreement clause. There's no way that you can exclude fraud, but if you have got a proper non-reliance clause in the agreement, then at least you've got some evidential argument to say that, in this case, Sky were not relying on the representation because they had signed up to a clause which said that they weren't relying on any representations. That particular point about non-reliance clauses was echoed again in a very recent case in the last few months of AXA Sun Life. That particular case did not concern fraudulent misrepresentation, but the point is similar. In that case, again, there was an entire agreement clause which said that the only terms and representations were those set out in the contract. And the court said, well, representations there meant representations within the contract. It wasn't referring to representations made before the contract. And critically, there was no non-reliance clause. There was no clause saying that that neither party was relying on any earlier representations made. So what are the conclusions that we can draw then from this case? I think the first thing is that there's no change to the law brought about by this case. It's always been the case that fraudulent misrepresentations liability for them cannot be limited. There is some suggestion that the notoriety of this case may make judges somewhat more conservative going forward in terms of allowing fraudulent misrepresentations to, if you like, undermine the commercial deal that's been reached on exclusions of liability by the parties. And I think it's still, as I said before, I think it's still going to be quite difficult in most cases to establish fraudulent misrepresentation unless you've got a George Galloway character who is so clearly dishonest. It also suggests to me that it's worthwhile, particularly if you're the supplier in a contract, checking the CVs of the people you're putting on the case, and again, from a supplier point of view, making sure that the sales team actually don't act independently of the delivery team, that they listen to what the delivery team say about what's possible and what isn't. The other thing that's worth bearing in mind is that there's a lot of evidence in this case that there were missing documents, particularly on the EDS side, and clearly it doesn't help your case if you haven't kept documents relevant to a potential claim. So it's important just to make sure you have those systems for document preservation. I've mentioned already the entire agreement clauses, and that's the end of that part of the session.